And Bill, as far as with the mediation, that's sort of what are
Yeah,
what
I
are we
mean,
looking at there?
both collaborative law and mediation relatively are new, or at the very least they're newer to this area. I know collaborative law it's really making a push here in the Memphis area. Mediation's been around a little bit longer. Again, this is something the parties can do without attorneys on the front end. So when you talk about it being quicker, generally that's the frame of reference where it's faster if the parties go to the mediator before they hire attorneys. If you hire attorneys and then go to see a mediator, I don't know necessarily that the process is going to be any quicker than it would with collaborative law, because at that point mediation is just one aspect of your divorce process where discovery and fact-finding will occur before you ever get to that mediation table. One of the strengths I see in mediation, again, is if there are these 2 or 3 big key issues that you can't come to an agreement on, if you cannot come to an agreement on those, you can draft a mediation agreement just saying what portion you will agree to, have your same attorney that's been with you throughout the process, and they can carry that forward in a courtroom setting. Whereas that's a positive, that can also be a negative, because I think in collaborative law, when you see that all that's on the line, you may be more motivated to settle. Whereas in a mediation setting, if you really want grandma's full-length mirror, you can just stop the whole ordeal and throw it all out the window over that one little thing, and go forward. So you get to keep your attorney in mediation. The mediator's a disinterested party. They try and give you the power to make your own decision, which is what I think both do. Both try and take the decision-making process out of the hands of the court and put it with you and your family where they should reside. Both are valuable tools.
Now, one question that comes to mind with me is, in divorce cases now, I think statutorily it has to be attempted to have been mediated before it can go to a hearing or a trial if it is a contested divorce. Now, the question that rings in my head is, if a family goes to a mediator prior to filing a divorce, or there's mediation that takes place during the collaborative law process, does that count once something is filed with a court as to whether or not the mediation prong has been met for it to be able to go to a hearing?
Sure. I think if you can ethically report to the court that either you or your clients attempted this process, that's enough to fulfill that requirement. Some judges in our jurisdiction actually will forego that if the attorneys report to them that no matter what we do, it's not going to happen.
Okay.
But it's something that should be attempted in all cases.